panel of judges of the International Criminal Court based in The Hague issued arrest warrants on November 21st for Prime Minister Benjamin Netanyahu, former Minister of Defense Yoav Gallant, and Hamas leader Mohammed Deif. The warrants issued against Netanyahu and Gallant were for alleged war crimes and crimes against humanity, specifically the intentional starvation of a civilian population. The allegations against the two men are stated to have commenced on October 8th, 2023. This was at a time when Hamas terrorists were still slaughtering civilians within Israel, and the IDF was battling to regain control of the southern part of the state that had been invaded. Any suggestion that Israeli leadership was implementing plans on October 8th that would accomplish mass starvation of the people of Gaza are absurd and, of course, untrue. But the facts do not seem to have gotten in the way of the court's deliberations and decision. What does this all mean? Well, should Netanyahu or Gallant travel to one of the 124 signatory countries to the Rome Statute of 1998, which created the International Criminal Court, that signatory country would have an obligation to arrest the men and deliver them to the International Criminal Court in The Hague. The issuance of an arrest warrant for Mohammed Deif is peculiar, as he was killed in an Israeli strike during the summer. The court apparently has other information and chose to disregard that fact. It also chose not to issue arrest warrants for other living leaders of Hamas who were deeply involved in the October 7th, 2023 attack on Israel and continue to lead Hamas through this war. Furthermore, the Chief Prosecutor of the ICC, Mr. Karim Khan, King's Counsel, seems to have gone out of his way to issue these warrants in an unusual manner. One might even say he has been deceptive, very deceptive. Typically, the ICC sends a team to the country which it alleges to have breached international criminal law. Mr. Khan and his team were meant to travel to Israel last May in order to do just that. At the last moment, without informing Israel, Mr. Khan instead applied to the court to issue the warrants. At best, that was highly unprofessional. After considering the case for 5 months, the court decided to issue the arrest warrants. This caused an international uproar. Many countries applauded this move. Others, like the United States, expressed rage. President Biden issued the following statement on November 21st. I quote, "The ICC issuance of arrest warrants against Israeli leaders is outrageous. Let me be clear once again. Whatever the ICC might imply, there is no equivalence, none, between Israel and Hamas. We will always stand with Israel against threats to its security." Close quote. President-elect Trump and his team have also been unequivocal in condemning the moral corruption and politicization of the International Criminal Court. And most interestingly, many European countries have been very careful in endorsing this imprudent step taken by the ICC. In recent days, the French government stated that it would not arrest Prime Minister Netanyahu or former Minister of Defense Yoav Gallant should they find themselves on French soil. Italy has been non-committal, likely hoping that the problem will disappear. Contrastingly, Foreign Minister of the Netherlands, Casper Veldkamp, was unequivocal in stating that the Netherlands would execute the warrant in its territory, a commitment echoed by UK Foreign Minister David Lammy. And of course, Canadian Prime Minister Justin Trudeau could not wait to declare that Canada would not hesitate to arrest Netanyahu. Quote, "That's just who we are as Canadians. Well, sorry, Justin, but that's not who we are. That's who you are. Prime Minister Trudeau's eagerness to declare that he would arrest Netanyahu should the Prime Minister of Israel step foot in Canada, which is, by the way, bloody unlikely. But this zeal on the part of Trudeau did not go unnoticed by President-elect Trump, who has issued some fierce ultimatums to Canada in recent days. But we'll get into that at the end of the podcast. The incoming Trump team has also made clear to the ICC that it will come down with heavy sanctions, presumably targeting members of the court and others, should these warrants not be rescinded. So this issue of arrest warrants for Bibi and Gallant, it's about much more than the actual arrests. It calls into question the foundations of the post-war international order of international law and the moral basis upon which it rests. We discuss these issues and more today with Professor Yuval Shany, an international law expert with the Hebrew University of Jerusalem, who is currently teaching at King's College in London. I spoke with Professor Shany on Sunday morning, just a few days after the arrest warrants had been issued. Professor Shany was a member of the UN Human Rights Committee from 2013 to 20 and served as chair of that committee from 2018 to 19. For further details of his deep experience in international law, please have a look at his bio in the podcast notes. I'm Vivian Berkovich, former Canadian ambassador to Israel, and now trying to keep up with the never-ending and overwhelming tsunami of existential challenges facing Israel unceasingly. Stay with us. Good morning. It's morning in the UK. Professor Yuval Shany on Sunday, November 24th. Thanks so much for joining State of Tel Aviv today.
Thanks for having me.
We are going to take a deep dive into the process that has been begun by the International Criminal Court. Several months ago, Chief Prosecutor of the ICC, Karim Khan, appeared before a panel of judges, I believe it was late May, and requested that they issue arrest warrants for Israeli Prime Minister Benjamin Netanyahu, then Minister of Defense, who has since been fired, Yoav Gallant, Yahya Sinwar, Mohammed Def, and Ismail Haniyeh. Haniyeh, Def, and Sinwar have all been killed by the IDF and other forces. And the ICC, for some reason, does not accept that Def is actually dead, but we'll just leave that to the side. But the main point is that late last week, the judiciary of the ICC did issue those arrest warrants in the names of Def, Netanyahu, and Gallant. And hence ensued an international storm of controversy. I just wanted to sort of make the context very clear. And you, of course, are an expert in many things ICC. And it's so great that you're able to be with us today. So first of all, what I want to focus on with you is the broad jurisdictional issue. And we're going to break that down into parts. But as an organization, there are 124 countries that are signatories to the Rome Treaty, which establishes the International Criminal Court, established it in 1998, I believe, and it became operational in 2002. Israel is not a signatory, and the United States is not a signatory. Palestine has been sort of accepted as a kind of signatory. Can you just explain to our listeners how, where, and why the International Criminal Court assumes jurisdiction over the issue of Israeli conduct and Hamas conduct, and on what basis, again, it feels it has the jurisdiction to issue these arrest warrants?
So, as you mentioned correctly, Israel is not a party to the Rome Statute that established the International Criminal Court. However, the court can exercise jurisdiction over nationals of non-state parties if they have committed the crimes alleged to them in the territory of a state party. So when American troops were accused of engaging in torture, for instance, in Afghanistan, the court was able to commence an investigation on the basis of the fact that Afghanistan is a member of the court, although the United States is not. Of course, this investigation did go away at some point. But in terms of principle, this has been the principle that it is sufficient for jurisdiction that one of two conditions are met. Either your state of nationality has joined the court, or you have committed the alleged crimes in the territory of the state party. Now, the Palestinians have long sought the acceptance to a variety of international bodies and international treaties. They have long sought UN membership, as we know. This has not yet happened, but they did come quite close to that because 13 years ago, the General Assembly did decide to upgrade the status of the Palestinians from observers, mere observer, to what is called an observer state. And that, in a way, you could say, opened the floodgate, because on the basis of the recognition of the General Assembly by a majority vote that Palestine has a legal status that is equivalent to that of a state, although I should say it's extremely dubious whether they meet the formal conditions for statehood. But this allowed the Palestinians then to go from organization to organization and to seek acceptance. And in 2015, the member states that are parties to the Rome Statute that established the International Criminal Court did accept Palestine as one of their member states. And that the combination of this doctrine by which the territory is enough and the accession of Palestine in 2015, that really exposed Israel to this new legal risk, because suddenly acts by the Israeli government or the IDF in what are called the Palestinian occupied territories in UN parlance had become at least potentially open to investigation and criminal prosecution by the ICC. And this is exactly what the court has done last week by basically saying Palestine is a member state, the alleged crimes were committed on its territory in the Gaza Strip, and we have the legal mandate to proceed forward with the case.
Is it fair to say that the ICC as an organization based its acceptance of Palestine as a signatory state, in effect, to the treaty, thereby allowing Palestine to make claims to the International Criminal Court directly? Is it fair to say that the ICC relied heavily upon the fact that the United Nations had granted Palestine this observer state status?
Exactly. This was the key consideration that had facilitated it. And actually very few countries had raised their flags. I mean, Germany was expressed concern, Canada expressed concern at the time, but this has gone almost without any major controversy among the member states of the ICC. So it was one shoe dropped in New York and the other shoe dropped in The Hague.
There are a number of ethnic, national groups in the world that do not have states of their own and desperately want them. For example, the Kurds, the Basques in Catalonia. We could go down, there's a long list. Is there any precedent for the way in which Palestine has been treated by both the UN and the ICC for other non-state wannabe states?
Well, I think the Palestinian case is quite unique at the UN level. We have seen in some specific regional context a similar attempt to recognize non-state for certain purposes. I mean, the one example that comes to mind is Western Sahara, where the African Union did accept the local entity, the Sahrawi, as a member state, although it doesn't meet the conditions of statehood either. But that was, like I said, that was something that happened within a regional context. They didn't have such success at the UN. So I would say that although initially the PLO did ride on the successes of the African National Congress in getting some recognition as an observer at the UN, its later successes in getting effectively quasi-state status have been, I would say, unprecedented at the UN level.
So that really clears up and explains the admissibility of a complaint on the jurisdictional basis.
Right. But I would say that even though the question, I've just explained how Palestine was able to join the court and on that basis authorize the court to conduct investigations on its territory, there is still a serious jurisdictional objection that Israel and other states had raised concerning the Oslo Accords specifically, because the Oslo Accords do block the Palestinian Authority from exercising jurisdiction over Israeli nationals. And this is explicitly mentioned in the Accords. And in fact, the Palestinians more or less respected that provision and have never tried to prosecute an Israeli national in their own domestic courts. So Israel had argued that Palestine cannot give away to the court more than it actually has. So if it itself doesn't have the power to prosecute Israelis, how can it transfer that power to the court? Now, this is not just a fringe argument, because one of the three judges that heard the case first in 2021 has accepted this argument and basically said that by that reason, Palestine cannot actually confer the court jurisdiction over Israeli nationals. The two other judges who sat on the 2021 case, which dealt with the jurisdictional questions in the abstract, have said, well, this is a too complicated issue. Let's kick it down the road. And once arrest warrants are issued, if it will become relevant, we will discuss it at that point in time. And quite shockingly, the court that issued the arrest warrants last week have decided also not to discuss the issue and kick the can again down the road. Not clear why and how now it's going to be discussed, but Israel and actually, and again, a number of states have made again the same arguments that the court does not have jurisdiction over Israelis, but the court nonetheless ignored essentially this argument, said something not clear that it could be raised at a later point in time, not clear exactly where and when, and went ahead to issue the arrest warrants. So that's this is, I would say, somewhat troubling and less than satisfying aspect of the procedure so far, which hasn't really gotten much attention in the coverage of the case.
Yeah, well, in the era of clickbait, anything that actually requires deep analysis tends not to get much attention. So we're going to do our bit here to remedy that. Who was the dissenting judge in 2021?
That was a Hungarian judge, Judge Kovács. He was the only one who engaged with the actual substance of the arguments on the Oslo Accords and wrote a very lengthy decision, more than 100 pages, in which he reached the conclusion that Palestine has validly joined the court, but does not have the capacity to transfer cases involving Israeli citizens.
And since you've raised the Oslo Accords and the significant kind of challenge that arises from the Oslo Accords, I'm actually sitting here wondering, okay, the Oslo Accords were between the State of Israel and the State of Palestine. And the Palestinian Authority has been formed the government in the West Bank for 20 years, whatever it is. It was a 4-year term. Abbas was elected and he's still in power. The situation we have with respect to the Gaza Strip, which is what these arrest warrants relate to, primarily is a charge of an intention to starve the civilian population on the part of Gallant and Netanyahu. And that's in the context, of course, of the war that has been ongoing since October 7th in the Gaza Strip. The Gaza Strip is ruled by Hamas. Hamas is listed as a terrorist organization in almost every Western country and is, I would assume and hope, certainly not contemplated to be a legitimate ruling entity or party under Oslo or any statute. So How do we square that circle?
Yeah, I mean, just in terms of technicality, the agreements were between Israel and the PLO. So Israel does not recognize, as we know, a Palestinian state. So they signed the agreement with the PLO that led, like you said, to the establishment of the Palestinian Authority. So again, the world of international law is an interesting world. You could say maybe a hall of mirrors where reality and law don't always sit together very comfortably. So the theory here is that the territory is a territory that is part of the Palestinian state or state to be. And the fact that the Palestinian Authority does not exercise effective control over the territory doesn't affect the legal title over the territory. So in the same way in which the ICC has reviewed practices by Russia in parts of Ukraine that Ukraine no longer controls, the same kind of thinking would allow the court to review activities in parts of the Palestinian territories which the Palestinian Authority no longer control. So the fact that Hamas is an illegitimate ruler and indeed has been designated by some countries, but not by the UN as a terror organization, this doesn't serve as an insurmountable obstacle to actually proceeding with the case.
Interesting. Okay. So that takes care of our issue, more or less, of jurisdiction. But the real guts of this case are in the complementarity principle. The way in which it sort of seems to have been overlooked, really, by Karim Khan, the chief prosecutor, by his advisory committee, and by this panel of judges that recently issued these arrest warrants. So please explain the principle of complementarity in international law, why it's so important in this case, and how it applies.
Right. So complementarity is, I would say, a foundational principle of the International Criminal Court. The idea was we're going to establish a court in 1998, like you said, which is going to deal with the worst of the worst. I mean, the worst international crimes that are out there. And we will do this only as a court of last resort. I mean, there is no interest of dealing with a case that is already handled by a domestic investigation or a domestic prosecution, because that will be both a waste of resources for the court. It wants to deal with the cases that are not treated elsewhere. And also, it would violate the notion of state sovereignty, which is quite important for states. And states do want to ensure that their legal systems have the right of way in dealing with difficult crimes. And this is indeed a principle which finds expression in the Rome Statute that instructs the court not to proceed with an investigation when you have another state that is investigating or prosecuting or had tried the same incident, the same issue, the same parties for more or less the same crimes. What we have seen here, I would say, is a sort of train wreck by reason of, let's say, failures by both parties. So I don't want to clear Israel here from blundering. The Israeli system is based on investigating specific military incidents, and that Israel has done, even in the conflict. But the broader issue, the broader policies, and these are typically the policies that implicate the politicians, the senior politicians, in the Israeli system, they are dealt with in war cases by a state commission of inquiry. And as we know, because of a variety of political tug of wars in the Israeli government, a commission of inquiry had not been established. So Israel has not done, I would say, everything that it could have done to convince the outer world that it is looking into all aspects of the war, including questions relating to humanitarian aid in Gaza, which no doubt raise serious issues.
I just want to interject with what I think is a salient point, and it's this. With respect to the State Commission of Inquiry, which is what the vast majority, I think the most recent poll said, something like 70 or 80% of Israelis wanted. Prime Minister Netanyahu has not accepted any personal responsibility for the disaster of October 7th, since October 7th, but more pertinently, he has made statements on a number of occasions, and he did so again last week, stating there is no need for a State Commission of Inquiry. And that cannot be helpful to the way in which the complementarity issue is perceived by the International Criminal Court and the global community. Do you agree?
Exactly, I agree. But I would say that even on and here I may have some disagreements even with the lawyers in government. I think that for specifically, I mean, there is a bigger question about accountability for October 7, and here I fully support a state inquiry, and I think that's the only way you can go forward. But on the question of humanitarian aid, there could have been some other ideas which could have satisfied the International Criminal Court, and even they become, in a way, entangled with this broader debate about accountability. So I think Israel could have done better. I mean, even open a police investigation. I mean, that could have been, even that, which is rather simple, I mean, they could have done that. Now, moving on to the ICC does, and the prosecution does have a policy which is called positive complementarity. So they believe in complementarity, at least they make representations to that effect. And positive complementarity means that the court would go out of its way to assist states with basically accepting their obligations to investigate and prosecute, and will share, for instance, information. And sometimes the court officials even give trainings in different countries. And the court has gone out of its way. I mean, even for dubious countries, to put it mildly, like Venezuela, where the Karim Khan went to Venezuela, he met with Maduro, and they have signed a memorandum of understanding in which the court would actually support domestic accountability in Venezuela over a number of incidents taking place there involving the government forces and the use of excessive force and the like. So this has been the tradition, but I would say that for Israel, he has gone in 180 degrees in the other direction. And that is that the court is basically Karim Khan at some point in time, when we don't know exactly where, when, and why, but it seems as if this was quite close to the date in which he requested the arrest warrants. He came to the conclusion that Israel would not be in a position to conduct an investigation. And up until that point in time, he was actually in a constant dialogue with the Israeli authorities. But from that moment, he, in a way, dissociated himself from that contact and went on with the arrest warrants without actually officially notifying the Israeli government that he's planning to go in that direction. Now, there is some back and forth, and that was also decided by the court last week. There is a legal question as to whether the prosecutor is required to give such a formal notification before he actually starts going down the path that could lead to arrest warrants and indictment. The statute provides that there is such an obligation. And indeed, in 2021, I refer to the previous decision. In 2021, the previous prosecutor did give a formal notification to Israel that she is investigating crimes relating to previous rounds of violence in Gaza, but also to West Bank settlements. And at that time, Israel didn't, I would say, respond directly or fully to that notification. So the legal debate is now, when you have effectively a new set of charges relating to the new war, do you have to issue a new notification? Or can you rely on a notification from 3 years ago that dealt with another set of issues? And Karim Khan, for a reason which I really cannot comprehend, has decided that this is a hill he will die on and decided not to issue the notification. And this decision had been challenged before the court, and the court sided in last Thursday with Karim Khan and took the position that since the formal notification was issued in 2021, and since this case is also about Gaza, and previously there were also issues relating to violence in Gaza in 2014 and 2018, there is no need to issue a new notification, which I think is a very problematic, highly formalistic decision, which really defeats the object and purpose of the complementarity framework, which is to put states in the best position they can be in order to conduct the domestic investigation. So I would say Israel has perhaps gone out of its way not to help the court find complementarity in its favor. And the court has gone out of its way not to allow Israel a fair chance to assert complementarity. And the outcome is now before us, that Israel effectively was deprived of the opportunity to assert complementarity about the situation, humanitarian aid situation in general terms. It's still, I should say, if there will be tomorrow a police investigation against Gallant and Netanyahu relating to the charges before the court, this is something that Israel can still invoke. But at this point in time, I think getting there is going to be very difficult, legally speaking.
So first, and also, if Israel was to establish some sort of inquiry, police inquiry, or by other means, there remains the question of whether or not Israel would actually submit to the jurisdiction of the court in terms of Israel's not a signatory, does not accept its jurisdiction. So how does Israel get any such evidence?
But Israel has crossed that Rubicon. It did submit in early September. Well, in September, it did submit two direct challenges to the court. This was the first time Israel directly engaged with the court. The Americans have also, in a way, crossed that Rubicon in August and submitted also their positions to the court, advising the court not to take jurisdiction. So Israel, as a state, even if it's not a state party, does still have certain procedural rights before the court, and it will be in a position to communicate with the court if it so chooses. Whether it does so or not is more of a political issue than a legal issue. The obligation on state parties kicks off when a person is found within their territory. When a person is in the territory of another state, there is no legal obligation. There may be attempts to do something like that. We have seen Spain seeking the extradition of Pinochet from the UK when he was in the UK in the late 1990s for medical treatment. But there will be also questions of immunity. And non-member states are clearly bound by immunity. With member states, head of state immunity, this is the position that the court is taking, does not kick in. But I should say this is even within the membership of the ICC, it's a controversial approach. And we have seen recently Putin actually visit Mongolia, and Mongolia, a member state, pushing back, saying, we do not accept the primacy of the court's jurisdiction over our diplomatic obligations. And we've already heard, even with regard to Netanyahu, a couple of member states, Argentina and Hungary, saying that we will welcome the prime minister regardless of the ICC obligation. So I don't think extradition is a real concern. I think the real concern for international travel, if there's a mechanical failure in the plane and he has to land an emergency landing in a place like Ireland or even Canada, whether that could actually put him in trouble. And I would say, yes, it would put him in trouble.
Absolutely. And that, of course, people may not realize that these mechanical issues with airplanes happen quite frequently. And there have been a number of occasions, even just in the last few years, where commercial airlines, some from the United Arab Emirates, I think also from Jordan, have had to touch down in Iran with civilian aircraft and passengers. And there have been Israelis on board. So these situations do arise, and I'm sure that Benjamin Netanyahu has a team of lawyers thinking these matters through for him. But in the near future, it looks like if he's going to be going anywhere, it'll just be to Hungary, Argentina, and the United States. But there's also the possibility
to Russia.
Right. And maybe, who knows, maybe he'll do that. The reaction to this issuance of these arrest warrants has been quite interesting. I'm sure you've been watching it as carefully as I have. So you have the countries that you've already noted, the sort of outliers, if you will, the Argentinas and Hungaries that are signatories, but are saying, you're welcome anytime. Nobody's going to be arresting you here. Then you have the United States, which is not a signatory, and we can presume safely that he could travel there. And then you have Europe, and all member countries of the EU are ICC signatories. But the reactions have been different across the EU. For example, Giorgia Meloni, the Prime Minister of Italy, I think was quite toned down and said she'll be looking at things, examining things. Of course, the Prime Minister of Ireland was smacking his lips and saying, can't wait. We'll arrest him with unbridled glee. France and the UK were a touch more nuanced. Starmer, not so much. Macron, yes. And Germany as well was, we'll take it under advisement. So we're seeing, in my view, a real range of reactions. The strongest, most enthusiastic prospective arresters of Netanyahu and Gallant, in my view, are Canada and Ireland. And I don't say that with any Canadian pride. What's your thought about the range of reactions we see and what it signals?
That's more, a question that has to do with international geopolitical politics. And it's not, I would say it's also related to the election of Trump in the United States. So I think it's more about signaling where you're situated on the spectrum of, the hardcore liberal camp and the more, I would say, populist or realist schools. So I think countries are using this more of a proxy to situate how they are with regard to the new U.S. administration than specifically with regard to Israel. I think it puts also states in a difficult, Germany, it was quite clear that Germany was a bit torn, right? Because they are, on the one hand, they consider themselves champions of international law. On the other hand, they have this historic connection to Israel. So maybe the wisest course is not to say anything publicly and hope that the problem will go away, that simply Netanyahu wouldn't ask for a visit. But you're right that for the court, this is in a way stretching its outer boundaries of support and legitimacy. It does put a lot of states in a very tight spot. And this could get, of course, much more dramatic after January 20, when the new US administration comes in, and some of the new figures in the administration have quite, let's say, stronger positions on this, including sanctioning states with, we heard Lindsey Graham yesterday even threatening Canada on destroying their economy if they side with the ICC. So I think it's going to be difficult. And also for the court. I mean, I think the court itself is not clear what would be the implications. And there will almost certainly be US sanctions like there were in the previous Trump era. But at that time, they were quite mild. And I think there is some appetite in Washington and in the more conservative or populist circles to go even more aggressively against the prosecutor and maybe even against the court itself and its ability to conduct business in financial markets.
There are so many reasons for Lindsey Graham saying that, and for other newly announced appointees of President-elect Trump for making these very aggressive and harsh comments with respect to Canada. It's not just the ICC. There's so much that's gone on between the two countries, but that's a whole other podcast outside of your area of expertise. So we have the sort of the Trump effect, let's call it that, because that's what it's being called, which again is, as you say, geopolitics, and to a degree it's reading tea leaves, but it does call into question the influence and credibility of the International Criminal Court in this particular moment. And there are some people out there who are saying this could actually herald the demise of the ICC, because the purpose for which it was established and the principles, the foundational principles like complementarity that form or that inform its operations and the way in which it approaches cases, that these things have been completely debased and corrupted. And the ICC really is not the august court body beacon of international justice and human rights norms that it was intended to be. Do you agree?
Well, I think that's a bit harsh. I think these are imperfect institutions and they suffer. And they're also, historically speaking, relatively new institutions. I mean, the court has been in existence just over 20 years and its track record is still relatively small. And it does have many problems. And some of them, we're reading papers and we're also seeing, there are scandals and there are issues that would probably you can find in any government department. I think that the key point here is still this is a fledgling institution. It has to tread carefully in terms of respecting its jurisdictional boundaries, respecting the principle of complementarity, and also applying care and caution in the kind of cases it puts forward. And I think there is a sense that here on all three accounts, it has taken this case to the limit. So I wouldn't say that any particular decision is unimaginable. I personally don't buy into this idea of that Israel is a democracy and therefore it should be given a free pass. Democracies also commit crimes, but democracies do have typically relatively robust legal systems which enable them to deal. And I think this is why I was critical of the court's approach to complementarity. But in fairness, like we said, Israel could have done a better job. Is it wise for the court to get on collision course with all the major international powers in the world? I mean, it's already on collision course, of course, with Russia. And Russian courts actually have criminal proceedings against ICC judges. I'm not even sure for what offenses, but it doesn't really matter in that specific country context. And now they will also alienate the United States. And they will alienate some key European constituencies. And they've also alienated in the past the African continent for excessive focus on the Africa. And that doesn't leave them with a lot of core supporters. And then the question is, can you, practically speaking, serve as the world's highest criminal court when most of the world doesn't trust rightly or wrongly, doesn't invest trust in you? So I think they could have played this out more carefully and more smartly, but it's difficult really to predict. Things are also, there could be developments even in this case, which will enable the court to find new ways to gain some support. Actually, this prosecutor was quite, when he entered, one of the first things he did was to close the U.S. investigation. The investigation against the U.S. in Afghanistan. And that at that time, I thought was quite a dubious legal decision, frankly, but a decision that did show good political instincts and understanding there are limits to the power of the court. You're not going to have trials anyway against U.S. personnel. It's now controlled by Taliban, so it's not anyway a situation where you conduct effective investigations. So you might as well let it go. And he also closed a number of other investigations which were going on for many years. With Israel, he has taken the opposite approach, which is to go aggressively and to actually stretch to the limit his powers. And I'm not sure that reflects well on, the political savviness of the way he is now conducting business.
One of the main objections and robust objections on the part of President Biden and other Western leaders is they say you cannot compare Hamas and Israel, even as flawed as the Israeli government may or may not be. You cannot put those two entities into the same case.
So that's a bit of a damned if you do, damned if you don't situation. So here I don't have such strong opinions in the sense that if they had gone only after the Israelis, of course, he would have been severely criticized for doing precisely that. And once he decides to go after both parties, he's criticized for creating a sort of a legal equivalency. I thought at the time that he could have first issued indictments against Hamas leaders, and then a few weeks later also bring in the Israelis. That would have been a better framing of the issue, which I think also reflect the different levels of gravity and criminal responsibility. But that's, I would say that's a matter of perceptions, and perceptions are often in the eyes of the beholder.
Thank you so much for being with us, being so generous with your time today, Professor Yuval Shany. Wonderful speaking with you, and I expect we will be meeting again in the not too distant future.
Thank you, Vivian. It was a pleasure being here.
It's heavy going, these legal issues, and I do hope that this discussion has helped to clarify some of the key legal principles involved in this case. I must share with you, in closing, that on Wednesday night I attended a reception and fireside chat in Jerusalem, featuring the amazing writer, journalist, and raconteur par excellence, Douglas Murray. The event was sponsored by NGO Monitor, which has, for many years, followed the money, followed which countries support which NGOs, and holding both sides to account. NGO Monitor's work is so important, and I urge you to check out their website. At one point in the discussion on stage, Douglas Murray shared a darkly humorous thought with the audience, saying that he was kind of hoping that once the warrants were issued, that Prime Minister Netanyahu would hop on a plane and land in Berlin and wait for the German authorities to arrest him on an ICC warrant for war crimes. I mean, it's a great fantasy, and he did get a good laugh and some applause, but it's obviously unlikely to actually happen for so many reasons. As a Canadian citizen, I have to say that I am deeply ashamed of the conduct of Prime Minister Justin Trudeau and his government. I know that many Canadians share my disgust at their pro-Islamist stance. They like to pretend they are being even-handed and favoring no one, but that is a load of poppycock. President-elect Trump has told Prime Minister Trudeau to reverse his position on the ICC warrants, as well as a few other things, like get control over the U.S.-Canada border, your side of it. And if he does not do so, President-elect Trump has said that he will slap 25% tariffs across the board on all exports from Canada. The U.S. is Canada's largest trading partner, And such a move would, as Senator Lindsey Graham has threatened in recent days, destroy the Canadian economy, or what's left of it after almost 10 years of unimaginably incompetent government at the federal level. And on that note, I expect that State of Tel Aviv listeners have heard about the violent anti-Semitic riots in Montreal last Friday night, which were followed by some ugly pro-Hamas demonstrations in a Jewish neighborhood in Toronto on the following Sunday, and the arrest of a Jewish journalist. Canada, for Jews, has become a very problematic place. Very. In the coming days, we will be releasing a podcast focusing on Canada, with interviews with the arrested journalist, Ezra Levant, his lawyer, and others. Thanks, as always, for listening. For those of you who are not paid subscribers, please consider supporting our work. It is labor-intensive, and if you are still here, then it is clearly of value to you. We do not want to paywall, because these issues really are so important, and we would like as many people as possible to listen to what we believe is our voice, and it's a voice of reason. But even we have to pay bills. It would also be great if you would like and rate us on Spotify or wherever you listen to your podcasts. Review us, like us on our Substack site, and follow us at State of Tel Aviv, all one word, on Instagram, and at State of TLV on X, formerly Twitter. And for our American listeners, hope you had a great Thanksgiving holiday. Thanks so much for being here. Until next time. We love hearing from you, so please comment on our website, stateoftelaviv.com, or send us a note to hello@stateoftelaviv.com. On behalf of the State of Tel Aviv core team, Jan Szabo, our creative, graphic, visual, and marketing man, Amir White, producer and editor extraordinaire, sound guy, who is also impressively patient with me and my boomer tech deficiencies, and our social media manager, who pitches in on everything, Maya Naftalin. Thanks to the team. Thanks to you for being here. We'll be back soon.